Chapter 7, Tort Law, Part 2, presented by Kelly Herzick. In Part 1 of Chapter 7, we covered both the classification of torts and intentional torts. In Part 2, we're going to discuss negligence, plaintiff's doctrines, defenses to negligence, strict liability, and damages. We will begin with negligence. Negligence is defined as an act, or sometimes failure to act, which is called an omission, that causes unreasonable risk of harm to others. Unlike intentional torts, where a party has to have intent to act, negligence involves the failure to exercise reasonable care to protect another's person or property. That's the test: failure to exercise reasonable care to protect another person or property. This is generally known as the reasonable person standard. We will talk about that just a little bit more later. In negligence action, there are 4 elements. Plaintiff has to prove a duty of care, breach of duty, causation, the link between the breach of duty and the damages suffered, and damages. So it's basically a 4-part test, and it really comes down to duty, breach, causation, and damages. We'll discuss duty of care first, which is the first element in the 4-part test that a plaintiff has to prove for negligence. In a negligence action, the plaintiff must first prove that the defendant owed a duty of care to the plaintiff. There are some duties that are established under the law, but in most instances, the duty of care is established by the reasonable person standard. The reasonable person standard is a measurement of the way members of society expect an individual to act in any given situation. I can give you endless examples of the reasonable person standard used in different aspects of negligence. But to determine the duty of care, a jury, or if it's a bench trial, the judge alone, must determine the degree of care and skill that a reasonable person would exercise under similar circumstances. For example, car wreck cases are where a lot of negligence cases are brought. In car wreck cases, juries are usually asked to determine the duty of reasonable care one driving an automobile owes to other drivers on the road, such as the duty not to drink and drive or the duty not to text and drive. Courts often ask 4 questions in determining whether a duty of care exists. How likely was the harm to occur? How serious was the potential harm? How socially beneficial was the defendant's conduct that posed the risk of harm? And what costs would have been necessary to reduce the risk of harm? As you can see from this and the reasonable person test, it's a balancing act to determine whether a duty exists from one defendant to a particular plaintiff. It's all about the facts and the circumstances of that particular case and whether a reasonable person in the defendant's shoes would have acted or should have acted in a certain manner. What about perilous situations? Does the ordinary person have the duty to risk their life or the duty to rescue others? Well, usually an average person does not have the duty to rescue others and risk their own peril, such as rescuing a drowning victim caught in the ocean's tides. However, that may change if you put the person in peril in the first place. If the 2 of you are on a boat and you're joking around and you shove a person into the water and they begin drowning, you likely have a duty of care to jump in and save them. The other aspect would be if the defendant could easily intervene in a perilous situation, like pulling a drowning toddler from a foot of water. While it's a perilous situation for the toddler, the defendant could easily rescue the toddler by stepping in the water without actually risking their own life. In that situation, there would probably be a duty of care to the toddler. Employers have a special duty under the law to protect employees from dangerous situations. They have the duty to keep employees safe on the job and to provide a safe workplace. This means that employers should take steps which are reasonably possible to ensure the health, safety, and well-being of employees. Legally, employers must abide by relevant health and safety laws and employment law, as well as the common law duty of care. Businesses also have a special duty of care to protect customers on their premises. Basically, the duty to warn of dangers or risks on the property, except those that are open and obvious. A good example is water on the floor in a grocery store. If the water is open and obvious and everyone can see it, you might not have a duty to warn. But even in that situation, most grocery stores will put up those little yellow signs that say caution, water on the floor may be slippery. And certainly if they are doing renovations and there's construction, they will put up big signs to warn customers that there is construction going on so that they will not be hurt on the premises. The second element in the plaintiff's negligence case is breach of duty. Breach of the duty of care is simply the actual act of negligence. It is a violation of the duty of care. For example, professionals such as lawyers have a duty of care to their clients. The duty of care for lawyers and doctors and other professionals is usually higher than the average person due to our specialized training. If a lawyer fails to follow the standard of care for his or her profession, it is a breach of the duty of care. For example, lawyers that miss deadlines, such as statute of limitations, breach their duties to their clients to exercise the same reasonable amount of care of otherly similar situated lawyers. When you're suing a professional like a doctor or lawyer, this breach is called malpractice. For the ordinary person in an ordinary situation, a breach of duty example might be to refrain from texting while driving or obeying traffic laws. If a person does text while driving or runs a stoplight and causes an accident which injures another person, that is a breach of the duty of care owed to other drivers on the road. It's that actual act of negligence, running the stoplight, texting while driving, being distracted while driving. Those are all examples of a breach of the duty of care. The third element in a plaintiff's negligence action is causation. Causation is the link or tie between the actual actions of the tortfeasor and the resulting harm caused to the plaintiff. If you put it another way, the breach of the duty of care by the defendant must be both the actual and the proximate cause of the harm suffered by the plaintiff. There are two things there, the actual cause and the proximate cause. The plaintiff usually has to prove both in the majority of states. Actual cause is known as cause in fact, meaning the defendant's breach of duty directly caused the plaintiff's injury. In other words, by running the stoplight when driving, a person hits a car and injures the plaintiff's back. That is a direct and actual cause of the plaintiff's injury. Proximate cause is known as legal cause, meaning the legal extent to which a person may be held liable for the consequences of his or her actions. Proximate cause is usually determined by foreseeability. In other words, could the defendant reasonably foresee that his actions would cause the plaintiff's damages? It would be reasonable, if you run a stoplight, that it would be reasonably foreseeable that you would hit another car and hurt someone in the car based on your breach of the duty of care in driving. If a defendant could not reasonably foresee the damages, a plaintiff's negligence case will fail due to lack of causation, because there is no proximate cause. Let's go back to the red light example that we just talked about. If someone runs a red light and hits another car, it would be reasonably foreseeable that running a red light would cause an accident by hitting another car in the intersection, and that would cause an injury to another person. That is foreseeable conduct, and that would be causation. That would be the proximate cause of the plaintiff's injury, as well as their injury in fact. However, if the car were full of explosives and the impact caused them to explode, injuring bystanders in the vicinity, the fact that the car had explosives would not be reasonably foreseeable, such that the bystanders injured would have a cause of action against the driver who ran the red light. Simply put, the explosion would not be a reasonably foreseeable circumstance of running a red light. There is a minority rule in a few states, and you probably ought to be aware of it, that in a small number of states, actual and proximate cause merge, meaning the bystanders in the previous example could recover since the car wreck was the actual cause of their injury. Now let's talk about damages. Damages are the last element in a negligence action that the plaintiff has to prove. The plaintiff must have compensable injuries as a result of the defendant's actions. Because one of the goals of tort law is to compensate those who are injured, the plaintiff can't usually sue under negligence for just nominal or no damages. It's a waste of the court's time. Compensatory damages are damages that reimburse the plaintiff for his or her actual loss. Punitive, or sometimes known as exemplary damages, are damages imposed to punish the defendant. These are intended to deter both the offender and others who hear about the award from committing the same acts. Example, the Ford Motor Company was hit with punitive damages in the case involving the Pinto because they knew about the exploding gas tank but still continued to put the car in production, risking the lives of others. To award punitive damages, the plaintiff must generally prove that the defendant committed gross negligence, an action committed with extreme reckless disregard for the property or the life of another person. And the Ford Motor Company, in putting the Pinto back into production and keeping it there, even knowing that the gas tank would explode and kill people, certainly meets that standard. We've discussed the 4 elements of a negligence case that the plaintiff must prove in court: duty, breach, causation, and damages. But sometimes the plaintiff needs a little bit of legal help to prove their case, and there are some doctrines that have developed over the course of the common law to assist the plaintiff in bridging the gaps. So what are the doctrines that help a plaintiff to win a negligence case? There are legal documents that help plaintiff establish direct evidence of negligence. One of those doctrines is an old one called res ipsa loquitur. It means the thing speaks for itself in Latin. The doctrine helps a plaintiff to prove, more likely than not, that the defendant's negligence was the cause of plaintiff's harm, even though the plaintiff may lack direct evidence of the negligence. For example, there may be no eyewitnesses to the defendant's act, or through reasonable destruction of documents, documents may have been destroyed, which would have otherwise proved the negligence. The doctrine of res ipsa loquitur helps the plaintiff fill in those gaps. To establish res ipsa loquitur, the plaintiff has to show that the event was a kind that ordinarily does not occur in the absence of negligence. In other words, it's unlikely that the plaintiff would have been hurt but for the fact that the defendant committed some type of negligence. Other responsible causes, including the conduct of third parties and the plaintiff themselves, have been sufficiently eliminated. And third, that the indicated negligence is within the scope of the defendant's duty to the plaintiff. If a plaintiff shows these 3 elements, then the burden of proof shifts to the defendant, who must prove by a preponderance of the evidence that he was not negligent. Res ipsa loquitur is basically a burden shifting of proof from the plaintiff. If they can show, more likely than not, that the defendant must have caused the negligence, then the burden shifts to the defendant to prove that they didn't commit the negligence. Negligence per se is another doctrine that will help a plaintiff in their negligence lawsuit. Negligence per se occurs when the defendant has violated a statute designed to prevent a certain type of harm from befalling a specific group to which the plaintiff belongs. If the defendant violates the statute and the plaintiff is part of the group meant to be protected, and the plaintiff suffers harm the statute is designed to prevent, it is deemed negligence per se. Therefore, if there's negligence per se, the plaintiff does not have to prove the duty of care. There's a good example. It's a statute preventing the sale of alcohol to minors, and a store nonetheless sells alcohol to a minor. The statute is designed to protect the public, specifically other drivers on the road. If the minor gets drunk on the alcohol the store legally sells him, and then the teen drives, causing an accident that injures the plaintiff, then the plaintiff can sue the store owner for negligence. Rather than showing that the store had a duty of care to her, the plaintiff can point to the statutory violation and establish negligence per se. It's basically kind of like in criminal law when you have regulatory violations and you have strict liability crimes. This is basically a strict liability type of doctrine that assists plaintiffs in negligence cases. Next, we'll discuss the defenses to negligence available to defendants in negligence actions. While there are some legal doctrines that help a plaintiff to prove negligence, there are a number of defenses a defendant can raise to rebut negligence claims. The first one is called contributory negligence. It's an old doctrine. This is a defense that allows a defendant to escape liability for negligence if the defendant can show two things. One, that the plaintiff failed to act in a way that would prevent him or her from an unreasonable risk of harm. And two, that the plaintiff's negligent behavior contributed in some way to the plaintiff's accident. A classic example of this would be speeding. Suppose that the defendant runs a red light and hits the plaintiff's car, but the plaintiff was speeding. The plaintiff then contributed to the action by her speeding, and that would be an unreasonable risk of harm, and so therefore the defendant would be able to use contributory negligence as a defense in the plaintiff's negligence action based on the car wreck. If the plaintiff was contributorily negligent in any amount, they are not entitled to damages. That seems like a pretty unfair rule. But this defense was once common in all the states, but now only 5 states follow pure contributory negligence, i.e. if the plaintiff is even 1% negligence, he or she does not recover. The last clear chance doctrine, in other words, the defendant has the last clear chance to avoid the accident, has been adopted by many states to combat that unfairness, while the vast majority of other states have abandoned contributory negligence altogether for a newer doctrine called comparative negligence. Comparative negligence in modern tort law has become the majority rule. There are 2 types: pure comparative negligence and modified comparative negligence. Pure comparative negligence means that fault is apportioned purely based on a percentage of fault. So plaintiff can recover even if he or she has the majority of fault in an accident. For example, a jury determines that a plaintiff is 60% at fault and a defendant is 40% at fault in a car accident. If the plaintiff suffers damages of $100,000, the plaintiff's recovery is reduced by his or her percentage of fault, meaning the plaintiff can recover $40,000 in damages from the defendant. Only about a third of the states follow this rule. Modified comparative negligence is certainly the norm, and it caps the plaintiff's ability to recover for negligence. The majority of states follow modified comparative fault, which is split into 2 main categories: the 50% bar rule and the 51% bar rule. In states following the 50% bar rule, which is Kansas, a party that is 50% or more responsible for an accident may not recover for damages, i.e. you have to be 49% or less responsible for the accident to recover. In states adhering to the 51% rule, a party may not recover if he or she is 51% at fault, i.e. it's 50% or less to recover. As I said, Kansas is in the 50% bar rule. Another defense that defendants can raise in negligence cases is assumption of the risk. Assumption of the risk is a defense where the defendant must prove that the plaintiff voluntarily assumed the risk that the defendant caused. There are 2 types: express assumption of the risk and implied assumption of the risk. Express assumption of the risk is when the plaintiff expressly agrees, usually in writing, to assume the risk posed by the defendant's conduct. Implied assumption of the risk means the plaintiff implicitly assumed a known risk. The defendant has to show that the plaintiff assumes the risk of the actual harm suffered. It must be specific. A good example is skydiving. If a plaintiff wants to go skydiving and take skydiving lessons, the plaintiff will usually be asked to sign a disclaimer and express assumption of the risk of skydiving, which is an inherently dangerous activity. If the plaintiff is then injured during the skydiving, defendant will likely use the disclaimer as an express assumption of the risk defense. However, you have to be careful as a business person with blanket waivers and assumptions of risks in contracts. An example is in your book about the gym, where at the gym they had an expansive, kind of broad assumption of the risk paragraph in the contract, which was held to be ineffective because it didn't assume or contain the express risk that the plaintiff actually sued for, which was a sauna bench collapsing. Remember when we talked a few slides back about the duty of care in perilous situations and the duty of rescue? Well, some states have passed what they call Good Samaritan laws. Good Samaritan statutes are statutes protecting people who come to the aid of others in emergency situations. If a Good Samaritan statute applies, plaintiff cannot sue for negligence resulting from the rendering of aid. A lot of this happens when people try to pull someone from a burning car. They may aggravate a neck or back injury, but they save the person from burning to death. The person who is injured cannot sue the people who rendered him aid for negligence in pulling him from the car. Another defense available in negligence cases is superseding cause. Superseding cause is an unforeseeable event that interrupts the causation change between the defendant's breach of duty and the injury the plaintiff ultimately suffers. Such an event interrupts the causation change and usually actually causes the accident. Suppose the defendant rear ends the plaintiff, causing damages to the plaintiff's car. Typical fender bender. When the plaintiff gets out of the car to look at the damages in the back of her car, another car unexpectedly comes out of nowhere and broadsides her car and knocks her to the pavement, resulting in broken ribs and a broken arm. If the plaintiff sues the defendant for all of her injuries in the accident, including the additional damages to her car and her personal injuries based on the car broadsiding her, the defendant may raise the defense of superseding cause. Defendant will allege that the third car unexpectedly hitting the plaintiff is the true cause of most of her injuries and not the defendant being sued. Strict liability is another major area in tort law. Strict liability is liability without fault. To prove strict liability, the plaintiff has to show three things. One, that the activity the defendant engaged in involves a risk of serious harm to people or property. Two, that it is so inherently dangerous that it cannot be safely undertaken. And three, it is not usually performed in the immediate community. Instead of banning such activities, the law allows people to engage in the conduct, but holds them strictly liable for any resulting harm, regardless if they intended the harm or not. An example of this is dynamite blasting or keeping a dangerous animal. As a business, suppose you want to build a new hotel and you buy a piece of land that has an old decrepit hotel on it, and you hire a company to come in and blast the old hotel down. The people performing the blasting are performing an inherently dangerous activity. And if anything goes wrong, even if they had no intention of causing any harm, even if they weren't really negligent, if something just crazy happens, they're responsible for the loss to the plaintiff. Today, strict liability is most commonly used when plaintiff claims to have been injured by a product that was unreasonably dangerous on the market. The last thing we're going to talk about is damages in tort cases. The first type of damages that the plaintiff can recover are compensatory damages. These are damages awarded to make the defendant whole as a result of the injuries that they receive. These are things like medical bills, pain and suffering, lost wages, and cost of repairing or replacing property. Pain and suffering is usually considered a non-economic damages. They're the soft damages. Recently in Kansas, the Kansas Supreme Court found that the statutory cap on non-economic damages was unconstitutional. So we'll see how that develops in Kansas. Nominal damages, again, are a small amount of money awarded to the plaintiff to acknowledge defendant did commit a tort, even though the plaintiff has almost no damages. Now, as I said before, if you have nominal damages at the outset or no damages, you can't bring a negligence action. Now, you may bring a negligence action and seek a larger award, but end up with nominal damages as an award from the jury. That's different. You see the difference? The final category is punitive damages, which we've talked a little bit about in post-trial motions in Chapter 3 and just recently here in this chapter. Punitive damages are awarded to punish the defendant for extremely outrageous conduct and to deter the defendant and others who hear of the award from committing similar misconduct. Large punitive damage awards have been under attack in recent years via tort reform, both statutorily, in other words, legislatures have passed caps on statutory damages, and in the courts themselves. In a series of court cases, the Supreme Court has articulated several tests on the relationship of punitive damages to compensatory damages. They have opined that a ratio of 4-to-1 punitive damages to compensatory damages would be constitutional, but that 10-to-1 would probably be unconstitutional based on due process under the 5th and 14th Amendments. There is an exception for especially egregious conduct. There are a lot of tests and that can be very complicated. What you really need to think about for testing purposes are the ratios generally, which would be 4-to-1 would be constitutional and 10-to-1 probably would not. Now, as we discussed in Chapter 3, if the punitive damage award is so large that compensatory damages versus punitive damages is out of whack based on the ratios set by the Supreme Court, a defendant can file a remediature motion post-trial for the court to reduce the damage award into constitutional zones. That is the end of Chapter 7. You have survived. And thank you very much.